Today, we're diving into one of the most bizarre and fascinating stories in Canadian legal history. It's a story about an appointment to the highest court in the land that ended up creating an incredible constitutional puzzle. And it all really comes down to this one question that sounds almost impossible, right? Can a judge, after they've been sworn into the Supreme Court of Canada, actually be unappointed? Well, believe it or not, it happened. Okay, so here's the setup. In 2013, a judge gets appointed, takes the oath, and officially joins the Supreme Court. But on the very same day, his eligibility gets challenged. That challenge works its way up to the Supreme Court itself, which then does something incredible. It declares that his appointment was void from the very beginning. So, how on earth did we get here? Well, let's meet the central figure in this whole constitutional drama, Justice Marc Nadan. His appointment was meant to fill one of the 3 seats on the Supreme Court that are specifically reserved for the province of Quebec. And this is where the controversy really starts. You see, Justice Nadan was a judge on the Federal Court of Appeal, and here's the crucial detail. He had been a member of the Quebec Bar for more than a decade, but he wasn't a current member. He also wasn't a judge on a Quebec provincial court. Despite that, he got the nod for a Quebec seat, and bam, the legal challenges started flying that very same day. To really get what this is all about, we have to roll up our sleeves and look at the actual law itself, the Supreme Court Act. The entire case hangs on the very specific, very precise wording that dictates who can be appointed to the court. And here it is, the heart of the whole conflict, laid out side by side. Just look at the difference in the wording. Section 5, which is the general rule for everybody, says an appointee is or has been a judge or lawyer for 10 years. It clearly includes former members. But then you look at Section 6, the special rule for the Quebec seats, and it says they must be appointed from among the judges or advocates of Quebec. So the million-dollar question is, does from among mean the same thing as is or has been? That tiny little difference in phrasing is what this whole legal battle is about. So this brings us to the first huge question the Supreme Court had to answer for itself. Based on that wording, is a former member of the Quebec Bar, like Justice Nadan, even eligible for one of Quebec's 3 seats? Or does that phrase from among mean you have to be a current member? The majority of the court, 6 out of the 7 judges who heard the case, came back with a clear answer. No, he wasn't eligible. Their argument was built on 3 main ideas. First, just the plain meaning of the words. They said if Parliament wanted former members to be eligible, it would have just used the same is or has been language it used in the other section. The phrase from among, they argued, implies you are currently in that group. Second, they looked at history, back to 1875. Section 6 exists for a reason, to protect Quebec's unique civil law system. And third, they said having that current connection is vital for maintaining the confidence of Quebecers in the court. But it wasn't unanimous. Justice Moldaver wrote a really powerful dissent. He basically said the majority was reading the law all wrong. He argued that you can't separate Sections 5 and 6, you have to read them together. Section 5 sets the basic qualifications for everyone, including that is or has been part, and Section 6 just adds one more layer. For 3 of those judges, they have to come from Quebec. He pointed out what he saw as a huge problem. If you separate the sections, then Section 6 doesn't even have a 10-year experience requirement. The majority had to borrow that part from Section 5. So his point was, you can't just cherry-pick the parts of Section 5 you like and ignore the parts you don't. And this quote from his dissent just cuts right to the heart of his argument. He's pretty much saying the majority just made up a new rule for reading laws to get the result they wanted, taking the 10-year rule but leaving the is or has been rule on the cutting room floor. It's a pretty sharp criticism. But this whole thing was about to get a lot bigger. You see, while this was all going on, the government actually tried to fix the problem. They passed a new law to make it crystal clear that yes, former advocates were eligible. And that raised a second, even more fundamental question. Can Parliament just change the rules for who gets to be a Supreme Court judge all by itself? To answer that, we need a quick history lesson on the court itself. When it was created, way back in 1875, it was just a regular creature of Parliament. Parliament made it, and Parliament could change it. But then in 1949, it became the final court of appeal for the entire country. And then, in 1982, the Constitution Act changed the game entirely. The new Constitution effectively locked in the Supreme Court's status and protected its essential features. And this led the majority to a groundbreaking conclusion. The makeup of the Supreme Court, who's on it and how they qualify, is no longer something Parliament can just change on a whim with a simple law. It's now been elevated to the level of the Constitution of Canada itself.
So, what does that mean in the real world? It means to change the composition of the Supreme Court, you have to use the single most difficult process for changing the Constitution, the unanimity formula. That means the federal government and the legislatures of all 10 provinces have to agree. The bar is, to put it mildly, incredibly high.
So with all of that legal and constitutional framework laid out, the court delivered its final historic verdict, one with huge consequences for Justice Nadon personally and for the entire country. So let's just boil it down. Here are the final answers. To question 1, is a former advocate from Quebec eligible? The 6-to-1 majority said a firm no. And to question 2, can Parliament change that rule all by itself? The answer was, again, a definitive no.
The immediate result of this was absolutely stunning. Justice Nadon's appointment was declared void ab initio, a Latin term meaning it was void from the very beginning. It was as if it never happened. He was never legally a judge of the Supreme Court. An unprecedented vacancy had been created, and then, just like that, uncreated.
But the long-term impact is what's really profound. Why does all this matter? Because this decision fundamentally redrew the Supreme Court's place in our government. It confirmed that the court isn't just a creation of Parliament that can be tweaked and changed whenever it's convenient. No, it's a core, constitutionally protected partner in the Canadian Federation.
And that really leaves us with this final, powerful question that this whole case was about. Is Canada's highest court just a creature of Parliament, or is it something much more fundamental, a foundational partner, essential to the very structure of the country? Well, in the case of Justice Nadon, the court gave us a clear and truly historic answer.